Peterson decided to move this case forward and to resolve the case. I'm first going to hear from Mr. Whittison. He's going to put what the negotiation is on the record, and then I'm going to have some questions for you as we go through that and make sure that everything's in order before I take any change of plea from you, okay? All right. Mr. Whittison?
Thank you, Your Honor. We are currently scheduled for a preliminary hearing in this matter. Mr. Peterson today is prepared to waive his preliminary hearing and enter guilty pleas. Mr. Peterson is prepared to plead guilty to counts 1, 2, 3, 4, and 5 of the amended information. And the negotiation with the state is that the state has agreed not to amend the child abuse homicide charge to murder or aggravated murder. And furthermore, the state and the defendant have agreed to recommend consecutive sentencing and imposition of the indeterminate prison terms at the time of sentencing. We have prepared a plea affidavit and reviewed that with Mr. Peterson in full. I've provided a copy to the state and to the court. The state has affixed its signature, and I've affixed my signature. Mr. Peterson is prepared to sign.
All right. Is that the state's agreement?
It is, Your Honor. I think before we proceed with the waiver, we probably should arraign him on the amended information.
And you've received a copy of the amended information?
I have, and I've also gone over that with Mr. Peterson. We'll waive formal reading of the information.
All right. Mr. Peterson, that amended information changes the counts that were originally filed. There's the same counts I understand that you're going to plead to today, and so let me identify what those are. Count 1 is child abuse homicide on a reckless basis, a first-degree felony carrying a maximum sentence of 5 years and maybe up to life. Counts 2 is aggravated child abuse. It's a second-degree felony, carries a maximum sentence of 1 to 15 years in the Utah State Prison and or a $10,000 fine. Count 3 is aggravated child abuse, also a second-degree felony, carrying same maximum sentence of 1 to 15 in the Utah State Prison and a fine of up to $10,000. Count 4 is a little bit different. It is aggravated child abuse, is a second-degree felony, but with the initials of a minor child of MP. Carries a maximum sentence of 1 to 15 years in the Utah State Prison and a fine of $10,000. And then count 5 is endangerment of a child. That's a third-degree felony carrying a maximum sentence of up to 5 years in the Utah State Prison and a $5,000 fine. All of those charges carry the same offense dates, being arranged between January 1st of 2022 and July 9th of 2024. And all of those charges can run concurrent or consecutive with each other or with any other sentence that you may be serving time on. Now, you have a right to a preliminary hearing on all of those charges. The state would have to put on evidence to show that a crime has been committed and that there is evidence to support each of the elements of each of those charges. That hearing currently is scheduled for May, and you're entitled to that, or you can waive that hearing and go forward with the negotiated plea that we've discussed here today. Do you want to waive your right to a preliminary hearing?
Yes, Your Honor.
And you've talked with counsel about that?
That is correct.
All right, then I will accept that waiver and find that it's been knowingly and intentionally made. And the state consents to the waiver?
We do, Your Honor.
All right. Mr. Peterson, I want to make sure that you're going forward with your eyes wide open, recognize the maximum sentences, and really in terms of whether or not there's a prison sentence here, that you know that prison term will be imposed by the court based on the negotiation and based on what's happened here, although we're going to wait and go forward with sentencing. I just want to make sure that you understand what your maximum risk is if you plead guilty here today. Do you understand that?
Yes, Your Honor.
All right, I think the state's prepared the statement in advance of plea. Maybe it was Mr. Whittison and Mr. Bichelle. But that document outlines the rights that you have and the waivers the court would need to accept in order for you to plead guilty today. Did you read that with your counsel?
Yes, Your Honor.
And did you understand it?
Yes, Your Honor.
And do you have any questions about it before we proceed?
No, Your Honor.
All right, as part of this document, first of all, it outlined the charges that you're pleading to, the maximum sentences that go along with those. It identifies what the elements of the charges are, and then there's a page and a half that outlines the factual basis for these pleas. Are the facts as they are outlined in this document, are they true?
Yes, Your Honor.
All right. And then I'll rely on that for a factual basis. It also, Mr. Peterson, indicates what the plea agreement is here, and is there anything that you're counting on, that you're relying on, that is not included in this document or that we haven't talked about here in court today?
No, Your Honor.
All right, then I will acknowledge that. And as I said, I have final say in terms of whether or not these run concurrent or consecutive, or how the sentences are imposed, but otherwise I will accept the plea negotiation. Finally, I think I looked at this. It does have the current language, the brand new language as it relates to withdrawing your plea. So that is current, and I don't need to go over that. But do you have any other questions for your counsel or for me before I have you sign this document and before we take your plea today?
No, Your Honor.
All right. You are satisfied with the counsel that you've been given by your two attorneys?
Yes, Your Honor.
All right. Do you feel like you're thinking clearly today?
Yes, Your Honor.
And are you under the influence of any alcohol or controlled substances or medication that would make it difficult or impair your ability to make an informed decision today?
No, Your Honor.
All right. Mr. Whittison, any concerns on your part as his attorney?
No, none, Your Honor.
All right. And then, Mr. Peterson, if you're ready to go forward with your plea, I'll have you sign that statement in advance of plea. The attorneys will sign it as well. Once it's been signed by them, I will affix my signature to it, incorporate it into the record, including any oral statements that have been made here in court today. All right, Mr. Peterson, then to the amended information, count 1, child abuse homicide as a first-degree felony. How do you plead to that charge?
Guilty.
And to count 2, aggravated child abuse as a second-degree felony. How do you plead to that charge?
Guilty.
To count 3, aggravated child abuse as a second-degree felony. How do you plead to that charge?
Guilty.
And to count 4, aggravated child abuse with the initials of a minor MP. How do you plead to that charge?
Guilty.
And to count 5, endangerment as a child as a third-degree felony. How do you plead to that charge?
Guilty.
I'll accept those pleas, find that they've been knowingly and intentionally made, and I will enter the convictions for all 5 of those pleas. I do want a pre-sentence investigation report to be prepared by adult probation and parole. I think it's important, Mr. Peterson, although the fact that you're going to go to prison is a given in this case, I do think it's important that, first of all, you have the benefit of reviewing the PSI that's prepared, and you have counsel that can help you correct any factual errors. And in addition to that, that it include any information you want me to consider for purposes of sentencing. The state's certainly going to include any information that they want me to consider for sentencing. And then I want to know, part of what that document will tell me is what you're accepting responsibility for. And I think that's important for me to know as I make findings and determinations on the consecutive or potential concurrent sentence of any of those things. I know there's an agreement. I don't expect sentencing to take a long time because your counsel and you have agreed as to what that sentence might be. But I think I need to give it some thought. So I am referring it to APMP for you to go through the pre-sentence investigation report process. I expect you to cooperate with them. I also expect that you will give them any information they want, any information you want me to consider. And if you need any assistance, please consult with your counsel as you prepare for that. Ms. Toombs, were you able to determine if the 6th or the 7th worked better for sentencing?
For the state, it would be the 6th at 4 p.m.
And does that work for you, Mr. Whittison, Mr. Bichelle?
It does.
All right. So, Mr. Peterson, I'm going to set sentencing for May 6th. We're going to set that at 4 p.m. in person. I expect that the pre-sentence investigation report will be completed, and we will have it at that time. All right. I think that is everything. I'll have you go back over to the jail in anticipation of that sentencing. We'll make all of the paperwork here a part of the file, and that will be all for your proceedings today. Thank you. Mr. Bichelle, are you pretty close?
I'm ready, Your Honor.
Those all have an offense date stemming on or about July 9th of 2024. Those are the charges that if you plead to those, all of those sentences can run concurrent or consecutive with each other, and I would have final discretion as to what the sentence would be and also whether or not it runs concurrent or consecutive. I want to make sure you understand and appreciate the maximum risk you face if you plead guilty today. Do you understand that?
Yes.
All right. Mr. Bichelle has prepared, or he has a statement in advance of plea to go over with you. Did you read that with him?
Yes.
Did you understand it?
Yes.
And do you have any questions about it before we proceed?
No.
All right. Do you think that you are moving forward today thinking clearly?
Yes.
Okay. Are you are you taking any medication or other substances that might impair your ability to make a meaningful and thoughtful decision today?
No.
All right. And are you getting any treatment over at the Weber County Jail? Mental health treatment or taking any medication there?
No.
All right. You have met, though, with some doctors. And is there any concern that any concern from you about going forward today?
No.
All right. Mr. Bichelle and the state included in the statement in advance of plea an outline of the elements of the charges that you're charged with in this case, and then also facts about what happened on or about July 9th. The facts that are included there, are those facts all true?
They're true.
All right. Then I'll rely on that for a factual basis. Mr. Bichelle, do you want to supplement the record anymore in terms of your understanding as to whether or not he understands all of this and that you think he is entering a plea that is in his best interest, and also that he knows what he's doing?
I would, Your Honor. Thank you. As the court and the state is aware, during the pendency of this case, we retained the services of Dr. Rick Hawks and Dr. Kai Mendenhall to come and provide some assessments and some evaluations. We did a psychological evaluation as well as intellectual personality and an autism spectrum disorder evaluation. And from that evaluation, there were some findings that I can get into here in a few moments after we take the plea. But during that, and speaking with both doctors and my own interactions with Tyler over the pendency of this case, I have no concerns that he does not understand what's happening. I have no concerns in spending the time with him that entering this plea is in his best interest. And so I would wholeheartedly agree that he is prepared to go forward today with the full mental capacity necessary to enter a plea.
All right. Do you have any other questions here, Mr. Peterson?
No.
All right. Then I need you to sign that statement in advance of plea, acknowledging the rights that you have and the waivers you're giving the court prior to me taking your plea.
Okay, we're going to sign that page right there. Okay, now we're going to sign on the firearm restriction line right there. Oh, I printed that off weird, sorry. And we're going to sign one more right there.
So before you pass that to me, Deputy, Mr. Bichelle, will you look on page 1 under notification of the charges? It says under 7716.
Right.
Will you just...
We already did that.
You
We
did
changed
that,
that
okay.
today.
All
Yeah.
right.
That's why I
Thank you.
screwed up. I was reading my own document.
Oh,
Didn't put the
okay.
A in.
All right. And the attorneys have signed this. Mr. Peterson has now signed it. I'll affix my signature to it, incorporate the document into the record, including any oral statements that have been made here in court today. All right, Mr. Peterson, then to count 1, child abuse, homicide. It's a reckless mental state, it's first-degree felony. How do you plead to that charge?
Guilty.
All right, and count 2, aggravated child abuse, intentionally or knowingly. How do you plead to that charge?
Guilty.
Count 3, aggravated child abuse, intentionally or knowingly. How do you plead to that charge?
Guilty.
And obstruction of justice, a second-degree felony. How do you plead to that charge?
Guilty.
All right, I will accept those pleas. Find that they've been knowingly and intentionally made, and accept those pleas. Now let's talk about the special provisions that apply under 7716A 103 and talk about where we go from here. Mr. Bichelle?
Thank you, Judge. As we discussed earlier, Tyler did have an evaluation done, both by a psychologist and autism spectrum disorder specialist. And that evaluation came back with the diagnostic impressions that Tyler suffers from autism spectrum disorder, from generalized anxiety disorder, persistent depressive disorder, and, as Dr. Hawks indicated, other specified personality disorders with avoidant independent features. Because of that, under the statute 7716A 103, the parties, meaning myself and the state, can stipulate that he did have a mental condition at the time of the offense and that he could benefit from supervision or treatment. And under this statute, as we went over, because of this entry of plea under it today, the court can postpone sentencing until such time as an evaluation is completed and a recommended treatment plan is provided to the court as well. Given that the parties have stipulated, and given that I have spoken with representatives at Weber Human Services, which is required under the statute to provide said evaluation and treatment plan, that can be done within the next 30 days. That being said, that 30-day time frame would facilitate Mr. Peterson being released from custody. So our request would be, Your Honor, pursuant to this statute, he be released with any terms and conditions that Your Honor places upon him, including, but again, obviously not limited to, his availability to appear at Weber Human Services, to participate in the assessments which they will complete, and then the treatment plan that Weber Human Services will put forth for him. And we can probably have a review on that in about 30 days, according to Weber Human Services, to be able then to facilitate a further review on how treatment is going. I will let the court know, and I believe the state will have something along these lines as well, that while his release, he will live with his mother and his other siblings who reside in that home. I understand that that is somewhat tenuous upon Tyler being a model citizen and a model son and brother while he is residing in his mother's home with his siblings, and the state can address that more. So, Your Honor, my request would be today that we set a hearing about 30 days down the road. I'll make sure that Tyler gets over to Weber Human Services ASAP. I know we discussed being released also on pretrial level. I've explained to him what pretrial level 4 would be, which I think is appropriate. Honestly, and in full candor to the court, and getting to know Tyler and getting to talk with other individuals who know him, he's very regimented. I don't think there'll be any problems with him attending his treatments, attending any scheduled appointments, and even going to pretrial services on the required dates while we get through the things we need to pending the full sentence on this case.
All right, thank you. Ms. Toombs?
Your Honor, just a tiny clarification for the record. The state does agree that based on Dr. Hawks and Dr. Mendenhall's evaluation that Mr. Peterson does suffer from a mental condition that would meet the definition as articulated in 7716A 103. In terms of whether or not the defendant could benefit from supervision or treatment, the court has had an opportunity to review the mental health evaluation provided by defense counsel, and there are findings there, and I think the court can make those findings. I'm not necessarily stipulating to those findings. I do believe that the assessment will ferret out additional information and is appropriate and is required by the statute. In terms of the request by defense counsel to release Mr. Tyler Peterson today, the state agreed to submit on that issue. I will note that the court did ask us to make contact with the mother, and I will have Ms. Pitt give you the report and representations on that.
All right, thank you. Ms. Pitt?
We've spoken with the mother and Leilani, and they both agreed that yes, they would like him to come and stay with them at their home.
Okay.
But they don't have any concerns over that.
Okay. Any rules or regulations they wanted me to address for purposes of now? Okay.
Not that I'm aware of.
I will just supplement with, they will be in contact with our office. If they have any concern, if any concern develops, then they will contact our office, and we will be back before the court to ask for reconsideration of that.
Would it be appropriate, and I'm sorry I didn't mention this earlier, to issue a pretrial criminal protective order? They are domestic violence related. First of all, they're family members, but they are representatives of the victim here. And I think pursuant to the pretrial criminal protective order, I could issue one of those that simply provides that there be no aggressive behavior, no domestic violence, and that then would be in the system, so that if there was any issue as far as law enforcement being called, they would have something that they could rely on instantly, in which they could detain Mr. Peterson. It would just be paragraph 1.
I don't have any problem with it.
Okay, I'll ask that the state prepare that and send that over. So, Mr. Peterson, there's a lot that needs to happen between now and when this case is over. This is an important first step, and I think that it has been some time coming. You've spent a lot of time in custody, and I'm recognizing, based on what I've been told and also the recommendations from what I'm hearing from your mom and your sister, that they are going to, they want you to come and be with them. But it is under some really strict terms and conditions, okay? And I want you to understand what those are. First of all, because you haven't been sentenced yet, I'm going to release you from the jail, but I'm going to release you to pretrial, which means I don't know that that will happen today. It might not happen until tomorrow. But if it does, either way, I'm fine with it. But the terms and conditions of your release are going to be these specific ones. First of all, no further violation of the law, whether federal, state, or local. 2, I am going to issue a pretrial criminal protective order on behalf of the immediate family members of Gavin, which means your mom and your sister, and I think that there's another sibling that lives there, and any minor children that might be in the house. And the protection order is that you commit no domestic violence, no threatening behavior, no assaultive behavior, nothing that would qualify as domestic violence. That means that if you are frustrated, well, you handle that in an appropriate way. I'm not necessarily worried about a specific risk. I just want you to understand what those terms are. If there's an argument and there are raised voices, well, then you need to extricate yourself or leave the situation and turn and walk away, okay? You don't even get in a loud argument with anybody. Second of all, you certainly don't put your hands on anybody in an aggressive or angry manner. And I want you to make sure that you are in control so that we don't have to revisit this portion of what I'm ordering you, okay? Pretrial also is going to supervise. That PLR-4 status means they're going to see you at the Weber County Jail twice. PLR-4 is only one time a week.
I thought we said 5.
Okay, PLR-5 status, they're going to see you twice a week based on their schedule. You're subject to all of the things that they may want you to do there. I am going to order that you have no controlled substances that aren't lawfully prescribed to you, and you are subject to testing for that. And I am just going to put you on a random basis that way. Again, not because there's a significant issue that's been brought to my attention, but because I don't want there to be any question that you are acting appropriately and you're only using prescriptions based on how the prescription is written. No creative use of any prescriptions, no alcohol, and no going in any places where alcohol is the chief item of sale. In addition to that, this isn't part for pretrial, but this is part of the terms and conditions of your release. You are to engage with adult probation and parole immediately to get started on a pre-sentence investigation report. I do want that information because eventually there is going to be a sentencing in this case. And I'll need that PSI. Second of all, I want you to engage with the Department of Health and Human Services through their appointee, which I assume will be the Weber Human Services. I want you to go through an evaluation pursuant to this statute. And the department is ordered to provide a treatment assessment of the defendant and submit to the court treatment recommendations for the defendant. And then we will talk about when we need to have sentencing. I'll just refer, as it relates to all of that, to Section 7716A 103 sub 5. I think all of it is included in sub 5 for purposes of what they need to do. And then I also need a waiver of the time for sentencing.
We'll waive that, Your Honor.
And so, because you're not likely to be sentenced within 45 days. Do you have any questions of what I expect of you while you are, or when you are released?
No.
And are you going to abide by those restrictions?
Yes.
Okay. Then I also want you to stay in contact with Mr. Bichelle. Make sure that he knows where you are. If you are to spend the night somewhere other than at your mom's house, first of all, Mr. Bichelle needs to know why and where, and so does pretrial. And then they will send that information on to me. Lastly, you need to sign any releases that may be necessary over at Weber Human Services. You make sure that those releases are signed over there so that they can send them to Mr. Bichelle and frankly to the state as well so that those can be transmitted to me. And I think that is all for purposes of today. Did we confirm April 24th at 2 p.m.? Does that work for everyone for a review of the treatment assessment?
Actually, Your Honor.
That's a Thursday.
Yes, that does work for the state as well.
Mr. Bichelle, does that work?
It does, Judge. I may have one clarification question as well, if you have it.
Okay.
The order for Weber Human Services, will that be sent from here? Oh, so they
So
understand?
you need to draft that. You draft it? Okay. All right. Ms. Bick will draft it.
Okay.
And it will be sent over directly. It'll be made part of the file. You'll all have it, but she will transmit it as
thank
well. At least check in. I think that Dr. Mendenhall is aware enough of the situation that he can have a check-in with him immediately upon his release by tomorrow. But that evaluation itself may not be set up for another couple of days. You just be compliant with whatever they want. They say jump, you say how high, okay? All right, do you have any questions?
No.
All right. I think that is all on this matter, and I will see you, Mr. Peterson, with all of those things done on April 24th at 2 p.m., okay?
Okay.
All right, that will be all. Thank you.
Thank you, Your Honor.
All right,
May I go back to
and
minutes and just for a second?
we are in recess then.